I guess Clarence Thomas's idea of recusal is to just be the one who says the least, which is what he did today. Very few words, 3 questions I noticed, didn't take up more than a minute of the court's time each time.
Well, it's not so much what he's failed to say in the courtroom. It's what he's failed to say to any investigator, to his colleagues on the court, or to the public about what the facts are related to his recusal. And there's no place in the country where the rule of law, where due process never actually gets at the facts, except as to the Supreme Court and its own indiscretions and its own ethics problems. And so that remains a real problem. This is now the 3rd case that Justice Thomas has sat on where he has completely failed to make any positive case for himself as to why he should not be recused. And the court itself as an institution has completely failed to inquire into those facts. And there is no other party working for the court, like an inspector general or staff attorneys or anybody else, who have made any effort to interview him and find out what the facts are. And that is really inexcusable in a country of laws. And thank you, by the way, for mentioning my announcement today. If anybody wants to join the fun, come to WhiteHouseForSenate.com.
Senator, what else did you hear in the Supreme Court hearing today that we either have or have not yet covered that you think actually should be the way the court looks at this?
Well, the part that aggravated me to come at it from the other direction was Justice Gorsuch very pompously saying that we are writing a rule for the ages here, as if he's some high priest of policy who's going to be making age-long determinations. No, there's a Constitution. It says that the court is confined to deciding individual cases or controversy. The case or controversy here is, does this indictment violate any kind of immunity protection? This indictment. And instead, as you've pointed out on the show, Lawrence, they went on this long expedition through hypotheticals and through a lot of nonsense, with the result, and perhaps horribly to say, the intent of delay. And we'll see how quickly they respond. But you remember in Bush v. Gore, they decided that case the day after oral argument. When it was putting a Republican president into power, they didn't waste a minute. Now that they're protecting a Republican president by delay, we'll see how quickly they respond to this. But there's a lot at stake here. And just the arrogance of that, you know, they say that they're originalists, but they talk about policy as if they're legislators. They say they're minimalists, but they don't follow the language or narrow to the case or controversy. This argument has exploded so many of the pet theories of these justices that it's almost comical.
And they are willing to completely ignore 234 years of American history.
Yeah, that was the great point that Justice Jackson made. For as long as there has been in America, there have been presidents who did not enjoy immunity and who did not break the law. It's the justices who won't admit that the novelty here is, for the first time in history, a president who is likely a criminal. That's what's new here, not some new idea. And the idea that they have to look at every other presidency and future presidencies as potential problems when we have one presidency that was a problem, the presidency of Donald Trump, because of crimes he likely committed in office.